Hello there, welcome back to your favorite Law School Diaries episodes. So today we are going to dive into something very interesting, and that is a famous law contract case of Carlill versus Carbolic Small Ball Company. It's a very interesting case that every law contract student must know this case and have it on their mind. So this case is an 1893 Queen's Bench case, and the court it was heard in, it is a court of appeal, and the full case name is Louisa Carlill versus Carbolic Small Ball Company. So this case was decided on the 7th of December 1892. So let's dive into it. Let's look at what this case really aims at highlighting. This case aims at highlighting the elements that constitute what a contract is. So this case actually concerned a flu remedy called the Carbolic smoke ball. And as we shall later see in the facts that the manufacturers had advertised that the buyers who found it that this Carbolic smoke ball did not work would be awarded over something like £100, a considerable amount of money. So before we really go into that, let us see by the time the Court of Appeal had to really bring out all the elements, let us go into the details. So one thing you have to know if you're a law contract student and you've been there wondering, or you just said, let me go to YouTube and look up for this case. I get you, worry not. So one thing you have to know is that, like, even if they wake you up from sleep, you have to know that the Carbolic Small Ball Company had made a product called the smoke ball, and it claimed that it would be a cure for influenza and a number of diseases. This was in 1889 up to 1890, because around this time there was a pandemic going on, and actually in that pandemic, when you read history, they say that it claimed over 1 million people. So this company, the other company called Carbolic Small Ball Company, it went ahead and manufactured a product that we have seen that they call the smoke ball. It actually went in and advertised and said that we have found out that this tube, it is going to be a cure for the flu that is happening, and it also stated it with conditions. It actually published it in the Pall Mall Gazette and other newspapers. That was around 13th, 1891. And in that advertisement, it stated that it would pay £100 anyone who got sick with the influenza after using its product, according to the instructions it had provided with it. Actually, it showed that they had an intention to enter into a contract with the public or with anyone who complied to what they were advertising. It went ahead, it claimed that it had deposited over £1,000 with the Alliance Bank that was on the Regent Street, showing their sincerity in the matter. So there was this lady that is suing, actually, Louisa Elizabeth Carlill. So the advertisement, after seeing the advertisement, she went and bought one of the balls, and she even used it 3 times every day for almost 2 months. Yes, that was, starting with 17th Jan 1892. So that is on that date 17th Jan 1892, it's when she actually contracted the flu, even after having used the smoke ball that they were claiming that if you used it, you could not get this flu. As they had advertised, Louisa actually had to claim for the £100 from the Carbolic Small Ball Company, but unfortunately she sent them 2 letters. Her husband, the solicitor, wrote the 2 letters to the company asking them for the money, but they ignored her. And on the 3rd letter, that her 3rd request for her reward, they replied her in some anonymous letter where they stated that they are very sure that this smoke ball, if it is used very properly, they have complete confidence in the smoke ball's efficacy. So to them, they thought maybe she had not used it so well. So what they did, they were like, instead of us, arguing with you, and you make fraudulent claims against us. What do we need you to do? Come to your office. They told you to come to the office and use the ball each day and be checked by the secretary. Can you imagine? Then Carlill had to sue for the breach of the contract. On suing for the breach of the contract, you can imagine these people said the company argued that they had made no legally binding offer which was capable of acceptance, and thus there would be no contract. And Carlill's lawyer actually argued that the advertisement and her reliance on it amounted to a binding contract between her and the company, and they should pay the promised amount. So those are the brief facts in that matter. They may not be brief as I said, but they are the facts that you have to know. So what happened in the Court of Appeal? The judges in that matter rejected the company's arguments actually, and they held that the company indeed had made a binding contract with Carlill. The judges stated that the advertisement made, by them advertising that this and this, they were simply making an offer, and they were setting the terms set out in the, because they had set out the terms in the advertisement. So it amounted to an offer. So meaning that by satisfying the stated conditions for using the smoke ball, it constituted acceptance of the offer. So far we have looked at the two elements of a contract. One is offer, which they did, the Carbolic smoke ball company did, and there was acceptance. It is an element of contract. The Carlill lady accepted, so because she fulfilled all the conditions, and by purchasing or using the smoke ball, it constituted good consideration, because the money had been, they had said the money had been put on, like they had promised the money would be there to be rewarded. So her going and using that, as you dive into more of contract law, you will learn what a consideration is. And the company's claim that it had deposited the £1,000 onto the Alliance Bank, it actually amounted to an intention to be legally bound. So as you can see, the elements of a contract were clearly laid down in the famous case of Carlill versus Carbolic Small Ball Company. So this is a case that you have to have on your mind. This is a case that whenever anything arises and it concerns matters of contract law, you have to run to. So if you are a law student and maybe you have an exam, I encourage you to always use this case and contract specifically, because yes, there are very many other cases that define what a contract is, but if you rely on this case is a case that the lecturer knows. We are not really, the law is real. It's not that these things have been imported from somewhere and put here. No, it's universal. Every lecturer, wherever you go, at least they will have read about Carlill versus Carbolic Small Ball Company, and clearly it's not a hard case. So don't forget to comment, like, share, subscribe, and keep on your notifications so that in case a new video comes up, you're able to follow. Thank you.